Good afternoon. Before we have Mr. Hibner call the case, a couple of things to the attorneys. We appreciate your participating in this process. Line oral argument by Zoom enables us to keep doing the work of the Court of Appeals, which is the work of the people of Tennessee and your clients, obviously. If we should have any tech problems, we'll just take a pause, and Mr. Hibner and the IT people at the AOC have done a masterful job at all this. We'll work it out. So if we get stuck, we'll resolve it and then proceed. I call the case, Mr. Hibner.
Terry Wallace versus City of Lewisburg, Tennessee.
We'll hear from the appellate.
May it please the court, I'm Steve Waldron from the Rutherford County Bar, and I'd like to reserve 2 minutes for rebuttal.
That'll be fine.
This is a bench trial of an age discrimination case that was tried in April of 2016. Since it's a bench trial, rulings of law are de novo, as the court knows, and strict questions of fact are based upon, are presumed correct, subject to a preponderance of the evidence. Mixed questions of law and fact are de novo. I will read from the trial court's memorandum opinion briefly on page 6. It further appears and is found that Mr. Fuller's written statement that the plaintiff was terminated without cause was false. Clearly, there was a cause for the termination. The language in the separation notice was clearly meant to insulate Mr. Fuller and perhaps the city from legal exposure for the termination, and probably resulted from receiving legal advice. Nevertheless, the written statement was false. Under case law discussed below, this fact may support a conclusion, but does not require a conclusion that there was discrimination against the plaintiff. On page 7 of the memorandum opinion, last sentence, first paragraph, the court found, therefore, neither the written explanation for termination nor the explanation provided by defense witnesses at trial appears to be a sincere explanation for what happened. In its conclusion on page 14, the court said, the first 3 elements of an age discrimination claim are clearly present in this case. However, age discrimination has not been proven to have been a determining factor in the termination. An isolated statement by a council member about hiring a recent college graduate, which did not occur, and stress on other city employees due to budget issues do not establish that age was a determining factor in the termination of Mr. Wallace. The evidence suggests that the termination resulted from pressure by 3 city council members on the city manager, and the evidence suggests that the pressure was motivated by personal or political hostility to Mr. Wallace and by a need to find a scapegoat for economic sluggishness in the Marshall County economies during a period of national economic malaise. The termination was handled unprofessionally, but not in a manner that was actionable. Mr. Wallace, the plaintiff appellate, takes no issue with any of the facts found by the trial court except the mixed question of law and fact that his age was not a determining or but for cause for his termination. This is really quite a remarkable case for me. I've never had a court just find that the employer lied about a reason for termination, and they lied twice. They lied in the separation notice prepared by the city manager, and they lied at trial according to the judge. If the only reason an employer offers for its decision is a lie, the inference that the real reason was a forbidden one may rationally be drawn. That's the Versa versus Policy Studies case from Tennessee. Court, please there's a prima facie case that's made. Mr. Wallace was over 40. He was qualified. He met a reasonable employer's reasonable expectations. He was replaced by someone 21 years younger. He was terminated. And you go through the McDonnell-Douglas paradigm, then you get to the employer's position, which was not stated truthfully. And then the court says there's not enough proof to convince the court that age was a determining factor. Determining and but for, I think, mean the same thing. But for is the current verbiage that's used, and age doesn't have to be the sole cause, but the requirement's more than the substantial motivating factor. So Mr. Wallace was fired not for a legitimate reason, in fact, a nefarious reason, according to the court. So we have all of the road signs that are provided by the law for deciding employment discrimination cases are in Mr. Wallace's favor. He did nothing wrong. He is the victim of a vocational hit job. The question is whether age is a factor. One of the 3 city council members, Ms. Brandon Stewart, who is in her 40s and also an attorney, said at a public hearing about Mr. Wallace, we could replace him with someone right out of college for half the cost. Thankfully, we have a case, the Flynn versus Shoney's case that was decided in 1993, where a superior told Mr. Flynn in the termination meeting that for what we're paying you, we can hire several young bucks right out of college, out with the old, in with the new. Ms. Brandon Stewart essentially said the same thing. Beyond that, so that was specific to Mr. Wallace. Beyond that,
that was some time before he was terminated, though, was it not?
It was not a long time, Judge Bennett. It was not a long time. It was not 5 years like was said in the Brenner case that was relied upon by the court. It was some time, but not a long time. In fact, the problems for Mr. Wallace didn't start until the new council members were elected in June '09. And so it was sometime after that.
And they didn't hire a college student, and they didn't pay his replacement less, did they?
I don't know specifically what is, but it's interesting that the replacement, Judge Bennett, Mr. Lowe, the only experience he had for the job of industrial recruiter is what he learned by assisting Mr. Wallace. He had been a newspaper reporter. Then he worked in codes. He helped Mr. Wallace with technology. And so there's a dramatic difference in the qualifications there. I would call the court's attention to Jane Tilford. She was in her mid-50s. She was the second in command at the rec department. She testified that she and her boss, Guy Chambers, 8 years her senior, who was the same age as was Mr. Wallace, were on the hot seat all the time. She retired. She goes to City Manager Fuller, and she selected a retirement date. And she asked him, can they fire me before I reach that retirement date? Fuller says, no, I've checked with a lawyer. And the only reason Fuller could have checked with a lawyer was for an age claim. So he tells her, no, you can't do that. And curiously, 2 of the council members were after Fuller too. And so in January of 2010, he had announced his retirement on October 25, 2010. So evidently he had checked with a lawyer to see if he was protected ostensibly by age, or presumably by age, and he passes that advice on to Ms. Tilford. Ms. Tilford's boss, Guy Chambers, resigns, goes in and tells Mayor Woods, they don't have to fire me, I'm going to retire. Later, Chambers, who was replaced by somebody in his 30s, he didn't last long. Ms. Tilford applied for that job. She was then retired, and it was given to someone in her 40s. Perhaps the most compelling witness, certainly the most sympathetic fact to show that there was an age purge going on is that there was a gentleman named Harold Wiggins, an hourly worker at the rec department in his late 70s. One day, Mr. McRady, who was one of the three council members who were running the show at the time, shows up at the rec center. And he asked Ms. Tilford if Mr. Wiggins is still there, and she said he was. That very day, McRady goes to Fuller. Fuller talks to Chambers, the rec director. And that very day, Wiggins retires. Now, you have the normal road signs, over 40 replaced by somebody substantially younger. Then you have these individual things that are going on. Now, the court in its...
Counsel, but I'm
Yes.
sorry, let me interrupt you before you run out of time here. The trial court's statement that the evidence, which you read, the evidence suggests that the pressure was motivated by personal political hostility, which was and by need to find a scapegoat. That's actual finding by the trial court.
I would submit that that is a mixed finding of fact and law.
Why?
Well, it was found that's the reason for termination is really whether Mr. Wallace was terminated due to his age is a question of law. The finding that he was the victim of political hostility and personal dislike in an effort to shift blame over the economy is a fact. I would submit that the proof preponderates against that fact. There was no proof of that. Absolutely no witness testified to that. That's something that the court found, and frankly, it's not supported by the proof. The employer is not going to come in and say, I would be surprised if they say in their argument that we fired him because we didn't like him and we were just hostile to him, and that's tough. They're going to say that he had some performance problems, et cetera, and the court correctly found that that was not true. None of that was true. This is not a reduction in force case. The court relied on the Brenner case, which is a reduction in force case. Mr. Brenner's job at Avco was eliminated, and there was a formal reduction in force. Fuller testified that there was no citywide reduction in force, and Mr. Wallace's position certainly was not eliminated.
Was there not dissatisfaction with the industrial recruitment that had been going on?
That was it's almost like an act of God. Yeah, I mean, they were frustrated some, and he was given some criticism for that. But I would submit to you, that's not the reason. Why the city didn't follow, they blatantly disregarded their own personnel policy as to progressive discipline. They jumped 2 or 3 steps, Judge Bennett, in reaching the termination decision. They didn't follow their own policy. All of
that policy apply to somebody like an industrial recruiter?
It applied to all city employees.
Okay.
The state,
so he was considered an employee.
He was considered an employee, and state law says the city manager had sole responsibility to hire and fire and discipline, yet the council forced the city manager to make a contrary decision. So when it's all said and done, the most likely finding or holding is that age was the factor. Thank you.
Thank you, Counsel. You have your time for rebuttal. We'll hear from the appellate.
Good afternoon. Fetli Panello of Nashville Bar for the appellee City of Lewisburg, Tennessee. The main issue in this appeal is whether or not Mr. Wallace's age was a determining factor in the city's decision to terminate his employment. The trial court found that it was not, and we submit that the trial court was correct. Mr. Wallace was dismissed because a majority of the council members were dissatisfied or disapproved of his lack of performance as the city's industrial recruiter. Now, these were the facts that the trial court found. Mr. Wallace was hired in 2007 as the city's industrial recruiter. His job was to bring in new industries to the city. Unfortunately, beginning 2008 until 2010, the entire country was in a recession. And the city of Lewisburg, Marshall County in particular, was not spared from that recession. In fact, the unemployment rate in Marshall County was 20%. That was about first or second statewide. The trial court also found that there was really a budget problem in the city at this time. In particular, the city's recreation department was a drain on the city's budget. The city council was legitimately concerned about whether they could pay the salaries of the more senior officers because the expenditures just exceeded the revenues that were coming in at the time. Now, another fact that the trial court found is that there were 5 council members. 3 of them testified at trial, and then the deposition of one of them was admitted into evidence at trial. One of the council members did not testify at trial. Now, 3 of the 5 council members testified that they were dissatisfied with Mr. Wallace's lack of performance. They described his work as stagnant, lax, nil. Now, one of the council members, Mr. Minor, was a friend of Mr. Wallace. He considers Mr. Wallace a lifetime friend. And he said he himself was dissatisfied with the lack of performance, but he kept his opinions to himself because he considered Mr. Wallace a friend. When he was asked by defense counsel, he said, if he were not your friend, would you have said something about your dissatisfaction with his performance? And he said, yes. He would have voiced his concerns that he was dissatisfied with the lack of performance. So that shows you that 3 out of the 5 council members were not happy. They were unhappy with Mr. Wallace's performance as the city's industrial recruiter. That was a fact that was found by the trial court. Now, there was a question. I think this was a very important testimony. One of the council members was asked, did you believe that Mr. Wallace was doing everything he could or doing his best as industrial recruiter? He candidly answered that he had no reason to believe that Mr. Wallace was not doing his best to bring in new industries. But the fact of the matter is, at that period in time, no new industries were coming in Lewisburg when the economy desperately needed new industries to ease the unemployment problem. And for that reason, they were dissatisfied with his performance as industrial recruiter. All this goes to show that it was the dissatisfaction that was the motivating factor for the termination. His age, Mr. Wallace's age, had nothing to do with the city's decision to terminate his employment. Now, an argument was made.
What about the lack of following the policy, the employment policy of the city? Your opposing counsel suggested that that policy required progressive discipline, and that wasn't done here.
I want to point the court to the record that there was a July 31, 2009 meeting that was like, that Mr. Fuller, the city manager, testified was a form of disciplinary warning. He called Mr. Wallace, Mr. Lowe, who subsequently replaced Mr. Wallace, to talk about the general perception in the city that Mr. Wallace was being lax in his job as industrial recruiter. He testified that that was a form of verbal warning. Now, did he follow all the steps in the disciplinary process? He did not. But there is something in the record, the July 31, 2009 document, that will say that he, at the very minimum, alerted Mr. Wallace that there was a perception that he was lax in his job and people were not happy about it.
Ms. Pinella, why did the city misrepresent the reason for firing?
The city placed without cause on the separation on notice, and I believe the trial court found that was false. Now, city manager Fuller explained his reason for doing so. He said, on advice that they've been given by their lawyers in the city, they were to put without cause in the separation notice if the reason for termination has nothing to do with employee misconduct. The reason being the city did not want the employee not to be eligible for unemployment benefits. And so that was a practice that the city had been doing. If it's not employee misconduct, we put without cause in the separation notice. And that was fully explained at the trial when Mr. Fluler was examined, and Mr. Wallace himself admitted that because the separation notice stated without cause, he was able to avail himself of unemployment benefits. And that was the reason for that without cause statement in the separation notice.
We did not get a clear answer from Mr. Waldron on the pay compensation for the replacement employee. Was the replacement employee paid the same as the terminated employee?
I believe so, Your Honor. He was paid the same.
Thank you.
Just to conclude, there was an inference made that at this period of time, there were a lot of senior employees at the recreation department who were retiring. And it was suggested that gives rise to an inference that there was a pattern of age discrimination against these more senior employees. But that is simply not supported by the record. The person who retired during that time, Ms. Tilford, testified at trial that she retired during this time period because the pressures from the impending budget costs were just too much to bear. She was very stressed that with the impending budget cost, she knew that as the more senior officer, her position was likely to be cut. And so that's the reason for her decision to retire during that time period. Now, her testimony is corroborated by the testimony of the city mayor, Barbara Woods, and also by the chairman of the board for the recreation department, who both testified that the impending budget costs did impact the decision of senior officers at the rec department to retire during this period. But there was certainly no pressure on the part of the city to force older employees to retire during this period. And so that was made clear that there was no policy or practice of demoting or targeting older employees to retire during this period, given the financial pressures that the city was facing. So in conclusion, we respectfully submit that the preponderance of the evidence fully supports the trial court's conclusion that Mr. Wallace was terminated because majority of the council members disapproved of his lack of performance. The history just bears it out. There were no industry.
I'm sorry, let me interrupt you there. I want to ask you what you're saying there. Our court's conclusion was that the evidence suggests the pressure was motivated by personal or political hostility, not performance to Mr. Wallace, and by a need to find a scapegoat. The trial court didn't find there that it was because of this lack of performance, correct?
There was the statement of the trial court, Your Honor, was that subjective disapproval, and then the court added personal hostility. I would submit, though, that the record does not support that finding of personal hostility against Mr. Wallace.
So you both agree that the record doesn't support the trial court's finding that it was motivated by personal or political hostility? I
don't believe so, Your Honor. I
think we found something you all agree on, fairly. Given that nobody seems to think the record supports that, was that a finding of fact, or your opponent says it was a mixed question of law and fact? What do you say?
I believe that's a mixed question of law. In fact, Your Honor, the question of law is really, was age a determining factor in his termination? And we submit that it was not. But the court's finding that there was some personal hostility may be gleaned from the fact that the council expressed unhappiness over his lack of performance. That's a question of fact. So that's it for my part, Your Honors.
Okay, thank you. We'll hear from the appellant on rebuttal.
The July 31, 2009 document is interesting in that Fuller called in Wallace and Lowe, the codes enforcer, and told them the perception was that Lowe was doing Wallace's job. They both had to sign it. So Lowe was disciplined just as much as Wallace was, and Lowe got Wallace's job. They also testified that they continued working together because they genuinely liked each other. In fact, Wallace approved Lowe's applying for the job when Lowe applied. They continued to do just like they had always done. It was really a sham. Frankly, it was just something that Fuller had to do. So that document, it applied to both of them, and Lowe gets his job. Now, in the rec department, Ms. Tilford said we were on the hot seat all the time. You can't take the advantage that an employer has if it does a legitimate reduction in force, unless you do it. And that takes into account the people who are protected by age, and there was nothing of that kind done. So what the city has no explanation for is Harold Wiggins. He's not a management guy, not a high dollar guy. He was just an older employee that Mr. McRady wanted gone that day, and he got gone that day. And it was his age that did that. So if court please, I don't know that that's the smoking gun, it's about as close as you can get. There's no such thing as a rear end car wreck in employment law. That's why we have these guidelines, these road signs, and all of the road signs are in the plaintiff appellant's favor. Thank you.
Thanks to counsel for both sides. We appreciate your arguments. Mr. Hivner, if you would please recess court until 3 o'clock.
This honorable court is now in recess until 3 p.m. Counsel, you may leave the meeting at this time.